Welcome back to another incredible story about standing up for your rights. Before we begin, let us know where you're watching from in the comments below. Today's story is about how a routine court proceeding turned into a landmark moment for constitutional rights. The marble halls of the Suffolk County Courthouse had seen countless dramas unfold over the years, but none quite like what was about to happen on that crisp autumn morning. Karoline Leavitt, a 25-year-old journalist covering a local corruption case, sat quietly in the gallery, her red MAGA hat placed carefully on her lap as she reviewed her notes. She had been covering the high-profile case for weeks, documenting every detail for her readers at the local newspaper. The story had drawn national attention, bringing reporters from across the country to this normally quiet courthouse. But today's proceedings would become famous for reasons nobody could have anticipated. Judge William Harrison had presided over this courthouse for 15 years. Known for his strict adherence to decorum and traditional court protocols, he ran his courtroom with an iron fist wrapped in a velvet glove. His reputation for maintaining order was legendary, and his intolerance for any perceived disrespect was well documented. As the gallery filled with journalists, legal observers, and members of the public, Karoline placed her hat back on her head. She had worn it to dozens of other court proceedings without incident, understanding it was her constitutional right to do so as long as she remained respectful and quiet. The hat itself had become part of her professional identity, a symbol of her belief in transparent and fair reporting regardless of political affiliation. The bailiff's voice rang out, announcing the judge's arrival. "All rise." The Honorable Judge William Harrison presiding. The room fell silent as Judge Harrison entered, his black robes flowing behind him as he took his seat at the bench. His eyes swept across the courtroom, taking in the packed gallery, until they fixed on something that made him pause: Karoline's red hat. What happened next would spark a constitutional debate that would reach far beyond the walls of this courthouse. But to understand the full impact of what was about to unfold, we need to go back 6 months, to when Karoline first began covering court cases in Suffolk County. She had already established herself as a rising star in journalism, known for her meticulous research and unbiased reporting. Her coverage of local government had earned her both praise and criticism, but no one could question her dedication to accuracy and truth. She had interviewed Supreme Court justices, covered major political rallies, and had always worn her hat, a symbol of her belief that journalism should be transparent about potential biases rather than pretending they don't exist. The hat had never been an issue before. She had worn it in federal buildings, state houses, and even during White House press briefings. She understood the legal precedents protecting symbolic speech and had studied the relevant court decisions extensively. What she didn't know was that Judge Harrison had his own history with political expression in his courtroom. Years earlier, he had made headlines for demanding a lawyer remove a small rainbow flag pin during a civil rights case. The resulting controversy had nearly cost him his position, but he had managed to weather the storm by issuing a public apology and claiming it was about maintaining courtroom decorum, not suppressing expression. Now, as his eyes fixed on Karoline's hat, those who knew this history could sense what was coming. The judge's face darkened slightly, his jaw tightening in a way that his regular observers had learned to recognize as a warning sign. But what he didn't know was that Karoline had come prepared for this exact scenario. In her briefcase, alongside her reporter's notebook and pen, lay a carefully prepared document, one that would turn this confrontation into a teaching moment about constitutional rights and the limits of judicial authority. She had spent months researching similar cases, consulting with constitutional lawyers, and preparing for the possibility that someone might challenge her right to wear the hat. The judge cleared his throat, his microphone carrying his voice clearly through the hushed courtroom. "Miss, in the red hat, approach the bench." Karoline rose slowly, her movements deliberate and composed. The other journalists in the room began reaching for their notepads, sensing that something significant was about to happen. They had no idea that they were about to witness a moment that would be studied in law schools and journalism classes for years to come. As she walked toward the bench, Karoline maintained perfect composure. Her years of covering contentious stories had taught her the value of staying calm under pressure. She knew that what was about to happen would test not just her knowledge of the law, but her ability to stand firm in the face of authority. The courthouse's fluorescent lights gleamed off the polished wood of the judge's bench as Karoline approached. Judge Harrison looked down at her, his expression stern but controlled. He had handled countless challenges to his authority over the years, and to him, this seemed like just another opportunity to maintain the dignity of his courtroom. But he was about to learn that sometimes, the most powerful defense of dignity comes not from suppressing expression, but from protecting it. Because what Karoline was about to pull out of her briefcase wouldn't just challenge his authority, it would remind everyone present about the fundamental principles that make American justice unique. The tension in the courtroom was palpable as Judge Harrison prepared to speak. The other journalists leaned forward in their seats, pens poised over notepads. The attorneys present exchanged knowing glances, recognizing that they were about to witness something unusual. And Karoline Leavitt stood calmly before the bench, one hand resting on her briefcase, ready to demonstrate that sometimes the most powerful defense of liberty comes not from shouting, but from knowing your rights and standing firm in their defense. Judge Harrison's voice carried through the now silent courtroom with the weight of 15 years of judicial authority. Miss Leavitt, in this courtroom, we maintain certain standards of decorum. Political statements of any kind are not permitted. Remove the hat. Karoline stood perfectly still, her voice clear and respectful as she responded. Your Honor, I understand the importance of courtroom decorum. However, I'm a journalist here to cover these proceedings, and my choice of attire is a form of protected speech that doesn't disrupt the court's functions. The judge's expression hardened. Many in the gallery had seen this look before. It usually preceded someone being found in contempt of court. But Karoline wasn't finished. Furthermore, Your Honor, she continued, maintaining direct eye contact with the judge, I have here a compilation of relevant legal precedents regarding First Amendment protections in courtrooms. Her hand moved to her briefcase, but the judge cut her off with a sharp rap of his gavel. Miss Leavitt, this is not a constitutional law seminar. This is my courtroom, and in my courtroom, you will remove political statements of any kind, or you will be removed from the proceedings. Is that clear? The other journalists present began writing furiously. This exchange was quickly becoming the story, overshadowing the corruption case they had all come to cover. But what happened next would transform this moment from a simple clash of wills into something far more significant. Karoline opened her briefcase with deliberate calm, withdrawing a thick folder bound in blue legal paper. Your Honor, I have here a federal court injunction from the District Court of Massachusetts, specifically addressing the wearing of political clothing in courtrooms by members of the press. The judge's face flickered with surprise. He hadn't expected this level of preparation. But he quickly recovered. Miss Leavitt, are you attempting to lecture me on the law in my own courtroom? No, Your Honor. I'm simply exercising my rights as established by legal precedent. She held up the document. This injunction, issued just last month, specifically states that members of the press cannot be compelled to remove political clothing or symbols unless they are actively disrupting court proceedings or attempting to influence a jury. A murmur ran through the gallery. Several of the attorneys present began shuffling through their own briefcases, clearly interested in this development. Judge Harrison's clerk, a young woman who had been watching the exchange with growing concern, leaned forward to whisper something in the judge's ear. But Karoline wasn't finished. She pulled out another document. I also have here the transcript from Cohen versus California, where the Supreme Court held that wearing clothing with political messages is protected speech. And while the court can regulate conduct that would materially and substantially interfere with court procedures, merely wearing a hat does not meet that threshold. Judge Harrison's face had taken on a distinct redness. In 15 years on the bench, few had dared to challenge his authority so directly, and none had come quite so prepared. But his next words revealed that he wasn't ready to back down. Miss Leavitt, while I appreciate your academic interest in constitutional law, this court has the authority to maintain appropriate decorum. Your hat is a political statement that could influence others in this courtroom. Karoline nodded respectfully. Your Honor, I understand your concern. However, I also have here. She produced another document. A statistical analysis of political clothing in courtrooms across Massachusetts over the past 5 years. It shows no correlation between such expressions and any disruption of court proceedings. The gallery had grown so quiet you could hear the ancient heating system humming in the background. The other journalists had stopped writing, too captivated by the unfolding drama to take notes. Even the bailiff seemed unsure of what to do, his eyes moving between the judge and the young journalist in the red hat. Judge Harrison leaned forward, his voice taking on an edge of warning. "Miss Leavitt, you are treading dangerously close to contempt of court." "With respect, Your Honor," Karoline replied, her voice steady, "I believe holding me in contempt for exercising a constitutionally protected right would be problematic, especially given the presence of other political symbols currently visible in this courtroom." She gestured subtly toward the gallery, where several observers wore various political pins and symbols, items the judge had never previously addressed. This observation caused several heads to turn, noting the double standard being applied. The judge's clerk was now actively tugging at his sleeve, trying to show him something on her computer screen. But Judge Harrison waved her away, his focus entirely on the young woman standing before him. "Are you suggesting, Miss Leavitt, that I am applying the rules of this court selectively?" "I'm suggesting, Your Honor, that the Constitution applies equally to everyone in this room. And I have here..." She reached into her briefcase once more, producing yet another document. "A compilation of instances from your own court records where political symbols and clothing were permitted without comment." The atmosphere in the courtroom had shifted dramatically. What had started as a simple matter of courtroom decorum had evolved into something much more significant, a carefully prepared challenge to judicial overreach, backed by meticulous research and legal precedent. Several of the attorneys present had begun taking notes, clearly impressed by the young journalist's preparation and poise. A few were even nodding slightly, recognizing the legal validity of her arguments. Judge Harrison sat in silence for a long moment, studying Karoline with an expression that mixed irritation with growing respect. He had faced many challenges to his authority over the years, but never one so well documented and carefully presented. "Miss Leavitt," he finally said, his tone measured, "you seem to have put considerable thought into this matter." "Yes, Your Honor, because the principles at stake here go beyond any single hat or symbol. They touch on fundamental questions about press freedom, equal application of rules, and the balance between judicial authority and constitutional rights." She placed another document on the bench. This is a letter signed by 23 constitutional law professors from various Massachusetts universities, specifically addressing the issue of political clothing in courtrooms. "They unanimate." The judge cut her off with a raised hand. His clerk had finally managed to show him something on her screen, likely one of the very cases Karoline had cited. The courtroom waited in tense silence as he read, his expression gradually shifting from irritation to something more complex. But before he could respond, Karoline played her final card. "Your Honor, I have one more document you might find relevant." She withdrew a final paper from her briefcase. "This is a copy of your own published opinion from 2019, where you wrote, and I quote, 'The dignity of this court is not maintained by suppressing expression, but by ensuring that justice is administered fairly and consistently for all who enter these halls.'" The gallery erupted in whispers. Judge Harrison's own words, turned back on him with surgical precision, seemed to hang in the air. But the real significance of this moment wasn't just about a hat, or even about one judge's authority. It was about something much more fundamental, the ongoing tension between institutional power and individual rights. The other journalists in the room had recognized the broader implications. This wasn't just a story about a confrontation in a courtroom. It was about the importance of being prepared to defend your rights, about the power of knowing the law, and about the courage to stand firm in the face of authority. As Judge Harrison prepared to respond, the atmosphere in the courtroom crackled with anticipation. Because everyone present knew that what happened next wouldn't just affect one journalist or one courtroom, it would set a precedent that would be remembered and cited for years to come. Judge Harrison sat in silence for what felt like an eternity, his eyes moving between Karoline, the documents before him, and his increasingly insistent clerk. The courtroom remained hushed, every person present aware that they were witnessing a moment that would likely appear in law school textbooks for years to come. Finally, the judge spoke, his voice carrying a note of carefully controlled frustration. Miss Leavitt, while your preparation is admirable, there remains the question of precedent in this specific courthouse. This court has historically maintained strict standards regarding political expression of any kind. Karoline nodded respectfully, then reached once more into her seemingly bottomless briefcase. Your Honor, I anticipated that argument as well. She produced another document, this one bearing the seal of the Suffolk County court system. This is a complete record of political expression cases in this courthouse over the past decade. It shows that enforcement has been, at best, inconsistent. The document she held detailed dozens of instances where political expression had been permitted in Judge Harrison's own courtroom, from campaign buttons to political ties, from social justice pins to patriotic symbols. Each instance was meticulously documented with dates, case numbers, and photographic evidence. Furthermore, Karoline continued, her voice steady, I have statements from 7 other journalists who regularly cover proceedings in this courthouse, all attesting to wearing various political symbols without comment or censure. A slight murmur ran through the gallery as several of those very journalists shifted uncomfortably in their seats. One of them, a veteran reporter known for his progressive lapel pins, unconsciously touched the symbol he was wearing at that very moment. Judge Harrison's clerk was now openly distressed, repeatedly trying to show him something on her tablet. The judge finally turned to look, and his expression changed subtly as he read whatever was on the screen. Miss Leavitt, he said, his tone notably different, my clerk has just brought to my attention a recent Federal Circuit Court decision that appears to be relevant to this situation. Yes, Your Honor, Karoline replied. Would that be Jenkins versus Maryland Circuit Courts, decided last month? The case that specifically addressed political expression by journalists in state courtrooms? She produced yet another document. I have a copy of that decision here as well, with the relevant passages highlighted. The gallery erupted in barely suppressed chuckles. Several of the attorneys present were now openly smiling, clearly impressed by the young journalist's level of preparation. Even the bailiff had to hide a grin. Judge Harrison leaned back in his chair, regarding Karoline with what appeared to be a mixture of annoyance and grudging respect. You seem to have anticipated every possible objection, Miss Leavitt. Not every objection, Your Honor, she responded. Just the ones supported by legal precedent and constitutional principle. She paused for a moment, then added, I believe in being prepared, especially when fundamental rights are at stake. The judge's expression shifted again as he recognized his own words, a phrase he had used countless times to admonish unprepared attorneys in his courtroom. The irony was not lost on anyone present. And I suppose, the judge said, his voice now carrying a hint of resignation, that you also have documentation regarding the specific protections afforded to members of the press in court proceedings? Karoline nodded, producing another file. Yes, Your Honor. This compilation includes relevant Supreme Court decisions on press freedom in courtrooms, starting with Richmond Newspapers versus Virginia and continuing through to present day. It also includes specific guidelines from the Reporters' Committee for Freedom of the Press regarding courtroom attire and expression. The judge's clerk had finally stopped trying to show him more cases, instead sitting back with what looked like relief on her face. She had clearly recognized that this battle was already over, even if her boss hadn't quite admitted it yet. But Karoline wasn't finished. She had saved her most powerful argument for last. Your Honor, if I may make one final point? At the judge's weary nod, she continued, the fundamental issue here isn't really about a hat, or even about political expression. It's about the essential role of the press in our judicial system. She gestured to the other journalists in the gallery. We sit in these courtrooms day after day, observing and reporting on the administration of justice. Our role, as recognized by countless court decisions, is to serve as the eyes and ears of the public. That role requires transparency, not just in what we report, but in who we are. The courtroom had grown absolutely still as she spoke. Even Judge Harrison was listening intently now, his earlier irritation replaced by something that looked almost like interest. When I wear this hat, Karoline continued, I'm not trying to make a political statement in your courtroom. I'm being transparent about who I am and what perspectives I bring to my reporting. The public can then judge my work accordingly. Isn't that transparency precisely what serves the interests of justice? She placed one final document on the bench. This is a peer-reviewed study from the Columbia Journalism Review about the impact of transparent bias versus hidden bias in court reporting. The findings suggest that reporters who are open about their potential biases are actually more likely to produce objective coverage, precisely because they and their readers are consciously aware of those biases. Judge Harrison picked up the study, scanning its pages with evident interest. The courtroom remained silent as he read, the tension of the earlier confrontation gradually transforming into something else, a shared recognition that they were witnessing not just a legal argument, but a masterclass in the defense of constitutional principles. Finally, the judge looked up from the document. His face had lost its earlier anger, replaced by an expression that suggested he was seeing something new, not just in Karoline, but in the larger principles at stake. "Miss Leavitt," he said, his voice now carrying a note of genuine respect, "you have presented a thoroughly researched and remarkably well-argued case. While I maintain that this court has the authority to regulate conduct that disrupts proceedings, I must concede that your wearing of the hat does not meet that threshold." A collective exhale seemed to pass through the courtroom. But Judge Harrison wasn't finished. "Moreover," he continued, "your argument regarding transparency in journalism is compelling. It suggests a level of professional integrity that this court can only commend." He straightened in his chair, addressing not just Karoline now but the entire courtroom. "The dignity of this court is not maintained by arbitrary rules, but by the fair and equal application of law. Miss Leavitt has demonstrated today that preparation, respect for legal precedent, and the courage to defend one's rights are entirely compatible with courtroom decorum." The other journalists in the gallery had begun writing frantically again, recognizing that the story had just grown far beyond a simple dispute about a hat. This was now about principles that went to the heart of press freedom, judicial authority, and constitutional rights. But perhaps the most remarkable thing was Karoline's continued composure. She stood quietly as the judge spoke, neither triumphant nor relieved, but simply professional, a journalist who had done her homework and stood her ground. As she turned to return to her seat, Judge Harrison added one final comment. "Miss Leavitt." She turned back to face him. "I trust you'll be covering today's proceedings with the same thoroughness you've demonstrated in your legal research." "Yes, Your Honor," she replied simply. "That's exactly what the public deserves." The original corruption case would resume moments later, but everyone in that courtroom knew they had just witnessed something extraordinary. A young journalist had stood up to judicial authority not with protests or defiance, but with meticulous preparation, legal knowledge, and unwavering professionalism. And in doing so, she had reminded everyone present of a fundamental truth, that rights are not maintained by luck or chance, but by those willing to study them, understand them, and defend them with dignity and determination. In the days following the courtroom confrontation, the story of Karoline Leavitt and her stand for First Amendment rights spread far beyond Suffolk County. Legal blogs picked up the story first, analyzing her methodical presentation of constitutional law. Then national news outlets began covering it, recognizing that this wasn't just about a hat, it was about fundamental questions of free expression and the limits of judicial authority. Judge Harrison's admission that Karoline's arguments had merit sent ripples through the legal community. Within a week, 3 other judges in neighboring districts had quietly revised their policies on political expression in their courtrooms. The incident had sparked a broader conversation about the balance between maintaining courtroom decorum and protecting constitutional rights. But the most significant impact was happening in law schools across the country. Professors began incorporating the transcript of Karoline's argument into their constitutional law curricula. Her preparation, they noted, was a masterclass in how to challenge authority respectfully while standing firm on constitutional principles. The Suffolk County Bar Association organized a special symposium titled Expression and Decorum: Balancing Rights in the Modern Courtroom. They invited Karoline to be the keynote speaker, not as a journalist, but as someone who had demonstrated extraordinary understanding of constitutional law. Her speech that day would be remembered for one particular line. The Constitution doesn't defend itself, it relies on citizens who understand it and are willing to stand up for it. Back in her role as a journalist, Karoline found that her experience had given her a unique perspective on covering legal issues. Her articles now carried additional weight, informed by her first-hand experience in defending constitutional rights. Other journalists began seeking her advice on covering stories involving First Amendment issues. Judge Harrison, to his credit, embraced the opportunity for change. He established a committee to review all courthouse policies regarding expression and dress codes, ensuring they aligned with constitutional principles. More surprisingly, he invited Karoline to serve as a consultant to the committee, recognizing that her research and preparation had identified gaps in their existing policies. The young journalist's briefcase, which had contained such a powerful arsenal of legal precedents, became something of a legend in the courthouse. Law clerks would whisper about how she had transformed a simple dress code dispute into a landmark moment in constitutional law. Some even began referring to thorough legal preparation as pulling a Leavitt. Mrs. Chen's restaurant, where Karoline often went to write her articles, became a gathering place for young lawyers and law students. They would sit for hours, discussing constitutional law and the importance of being prepared to defend one's rights. The elderly restaurant owner would smile, remembering how Karoline had stood up for her rights too, in a different but equally important way. 6 months after the confrontation, Harvard Law School invited Karoline to give a guest lecture on practical applications of constitutional law in everyday life. The lecture hall was packed, not just with law students, but with journalists, activists, and citizens interested in learning how to better understand and defend their rights. The power of constitutional rights, Karoline told the assembled crowd, lies not in their existence on paper, but in our willingness and ability to defend them. Each of us has the responsibility to understand these rights and be prepared to stand up for them, not with anger or defiance, but with knowledge and respect for the law. The lecture was recorded and went viral on social media, reaching millions of viewers. Comments poured in from people sharing their own experiences of standing up for their rights, many citing Karoline's example as inspiration. The video became required viewing in journalism schools across the country, demonstrating the importance of understanding the legal framework that protects press freedom. 1 year after the courthouse confrontation, Karoline published a book titled Standing Ground: A Citizen's Guide to Constitutional Rights. The book wasn't just a retelling of her courtroom experience, it was a practical guide for citizens to understand and defend their constitutional rights in everyday situations. It became a bestseller and was adopted as supplementary reading in many civic education programs. The impact on the legal community continued to grow. The American Bar Association featured the case in their journal, analyzing how Karoline's approach could serve as a model for challenging judicial overreach. Law firms began using the transcript of her argument as a training tool for new attorneys, demonstrating how thorough preparation and respectful advocacy could be more effective than confrontational tactics. Judge Harrison, speaking at a judicial conference later that year, reflected on how the incident had changed his approach to the bench. Sometimes, he told his colleagues, it takes someone with the courage to challenge us respectfully to help us see where we've strayed from constitutional principles. Miss Leavitt didn't just win an argument that day, she helped make our court system better. The red MAGA hat that had sparked the confrontation became an exhibit in the Suffolk County Law Library's display on First Amendment rights. Next to it was a copy of Karoline's legal brief, the document that had transformed a potential confrontation into a teaching moment about constitutional rights. But perhaps the most lasting impact was on the next generation of journalists and lawyers. Applications to law schools saw a noticeable uptick, with many applicants citing Karoline's example as their inspiration. Young journalists began taking constitutional law classes, recognizing that understanding the law was as important as understanding how to write a story. In newsrooms across the country, editors began encouraging their reporters to study the legal basis of First Amendment protections. Karoline's example had shown that journalists needed to be more than observers. They needed to be knowledgeable defenders of constitutional rights. The courthouse where it all happened saw changes too. The rigid atmosphere that had once characterized its halls gave way to a more balanced approach to decorum. political expression, religious symbols, and other forms of protected speech were no longer automatically challenged. Instead, each situation was evaluated based on whether it actually disrupted court proceedings. As for Karoline, she continued her work as a journalist, but with an added focus on constitutional rights and civil liberties. Her articles now regularly appeared in major legal publications as well as news outlets. She became known as someone who could explain complex legal issues in ways that ordinary citizens could understand and apply in their own lives. The Constitution isn't just for lawyers, she would often say in her speeches. It's for every citizen who values their rights and is willing to stand up for them. The key is to be prepared, to know your rights, and to defend them with dignity and respect. The story of Karoline Leavitt and the MAGA hat became more than just a viral moment or a legal precedent. It became a reminder that in America, the power to defend constitutional rights belongs not just to lawyers and judges, but to every citizen who takes the time to understand them and the courage to stand up for them. Let us know in the comments if you've ever had to stand up for your constitutional rights and how you handled it. Remember to subscribe and hit that notification bell to never miss another story about ordinary citizens doing extraordinary things to protect our fundamental rights. Because sometimes the most powerful weapon in defending liberty isn't a loud voice or an angry protest, it's knowledge of the law and the courage to use it wisely.